Gary Ireland helps executives in transition to maximize income and benefits when joining a company and enhance severance and asserting legal rights when leaving. He also works with the executives in making smarter legal decisions when starting new businesses. Gary recently helped a senior executive in financial services who was marginalized and passed over because of her gender. Working behind the scenes, Gary helped her secure a substantial severance payment so that she was able to move on to her next opportunity. Gary also supported a very senior trader who needed to leave a toxic environment while being compensated for his bonus and unvested equity. Gary works with his clients to reach their potential, often working with coaches and recruiters to help with streamlining and expediting employment transitions, and with the media on matters that are requiring attention. And with that, Gary, take it away, Gary.
Okay, thanks everyone. And just to give you a little bit of background, my focus is on working with executives in transition and others in transition. Oftentimes when people have been marginalized or discriminated against, and then I work on the other side, I also work with businesses because I want to help both the business and the individual reach their potential. And sometimes even when I'm on the other side of a business, I try to point out that how we can work together, even when we're in litigation. So, and if you have any questions, please reach out to me. I've made my career and my personal life really intersect in that. I'll just give you a quick story. I've worked with my family, particularly my daughter, in opening up the Boy Scouts to young women. We've spent 8 years working on this project, and now it's called not the Boy Scouts, but the Scouts BSA. And that's in large part to my daughter, who was in Forbes magazine and went to the State of the Union. So I'm deeply committed to helping people reach their potential, and hopefully I can be of help to all of you. And if you have a question, please just put it in the chat room, and if I don't point it out, maybe Meryl or Sharon can step up. I'm going to try to share my screen now. I have a short presentation. Let's see here. So, and now slideshow from the beginning. Okay, and bear with me on this. Okay. So in a nutshell, I work with executives, and as I said, sometimes I litigate. Mostly I work behind the scenes or shoulder to shoulder with the companies, either getting them into a new situation, and oftentimes if they're high enough in the company, I want to make sure that they succeed, and there are other people that wanted those jobs. So I'll work with a career coach and a professional coach to try to, so that they can reach their potential. And because I've seen so many employees come into a situation and there's such resentment on the way in, having nothing to do with the particular employee. And I want to make sure that they succeed once they get there. And so oftentimes I'm able to convince the company to pay for a coach to help them reach their potential. And it's the same on the way out. Most companies don't want their employees to be gutted on the way out. They want to create ambassadors, even if it didn't work out. And you'll see more and more on LinkedIn, which I'm a big fan of, but more and more on LinkedIn, you'll see that there's an alumni area, and they may not stay with the company, but they want to have a good relationship with their former employees. So this is my family. This is taken from an article we did, and my late wife who passed away. She's still the soul of our family. And there's my best friend. So this is Equity and Equality is the Family Business. This is my daughter giving a presentation at a school for when she was still in high school on how to incorporate young women into the Boy Scouts. Okay, so let's get down to business here. What governs an employment situation? So you've got a contract, you've got the employee handbook, and you've got all of the other ancillary documents that they sometimes throw at you. So many times, this sounds like a no-brainer, but so many times I've seen clients have come into me and I was like, okay, can you give me your handbook, your contracts, just what I'm asking for here? And they won't have any of that. They've signed it online and they've never looked back. These are documents you really want to read, particularly if there's an equity component, meaning if you can have an ownership component, some stock, you want to make sure you read that, because oftentimes it's illusory, meaning they talk about stock, but they don't actually give it to you. And if they do give it to you, there's a way they claw it back, or it has no value. So you want to make sure that you've got all these documents. And to the extent you're also allowed to, you want to have your work product, meaning projects that you've worked on that are not confidential, that you would walk out of in the front door, so that when you go to a new opportunity, that you can show them, hey, this is the work I've done. This is what I've written. These are projects I've worked on. This is a PowerPoint, whatever it is. You want to be able to show that to other people when you're moving forward. And then there's the law, and that's where I come in. But I need to have as much information when someone comes into my office. So let's talk a little bit about updates, and this is going to be very quick. So medical marijuana in both, and I can't really speak to New Jersey. I'm in New York, in Manhattan, but medical marijuana was legalized. It was, it's now, you're not going to be prosecuted for holding quite a bit in your house and growing. And there are going to be dispensaries. There already are medical dispensaries, and there are going to be recreational dispensaries very soon. What the law is, what the gray area is, there are federal laws, but there are also impairment. And that's one of the gray areas. Like if you're tested at work, what's considered impairment, and what's going to be cause for being terminated. I'm working closely with some cannabis associations, and what we want to do is make sure that particularly folks that have a disability that requires, where they've been prescribed medical marijuana, that if they go in and they've smoked before or somehow ingested it before they've gone, like the night before, and then they go into work, that they're not going to be penalized for that. And, some of the areas we're working on are how do we determine if someone's impaired? Because obviously, particularly if there's a dangerous situation, you don't want someone being impaired on the job, but there are legitimate areas where medical marijuana comes into play, and particularly in alleviating pain, helping sleep, and so many other areas. So it's a gray area right now that is evolving. And then the employment update for COVID-19. There are so many, we're being bombarded by different media telling us, what's going to happen. Well, certainly the president wants everyone to get vaccinated. And at least in New York, religious exemptions are drying up. And I've worked with some deeply religious groups and individuals that it's not being recognized. That now there is court action that has slowed the process, but the consensus is that it's going to, at least for the short term, probably the exemptions for religion are going to be much more difficult at the corporate level. In the courts, they may play out much differently, particularly with the Supreme Court going in the direction that it has in the past and in the recent past. So in New York, I know that there's a real push to get everybody vaccinated, to make sure everybody's safe, and they don't really want to hear about religious exemptions, or there are medical exemptions, but even those are really narrow. So, and the area of law is evolving. So going back again, if let's say you've been terminated, and here's where I want to hear some questions, because this is what I deal with every day. Somebody comes in and they've been terminated. What are their rights? And what do they need? And going back to the beginning, you want to have your contract, you want to have an employee handbook, everything that governs your employment. Particularly if there's an equity component, you've got to make sure that you have that. Keep all these documents at home. Don't keep them on your computer at work. You want to make sure that you've brought them home, and hard copy or email them home if that's appropriate. Make sure you do everything. I've also, there are HR organizations that are so challenging. You want to make sure that it's okay to email yourself documents from work, even if they're appropriate documents. Sometimes they'll give you a hard time. And also you want to have your work product. Can someone check I can't see the chat room. If there are any questions, this is a good time to raise them, because we want to get a dialogue going, and I'd like to hear from all of you. This is not a one-sided conversation.
Well, so far there aren't any. I'm checking the chats. There aren't any questions. Did you see something, Meryl?
I have a question.
Sure.
Well, I had COVID questions I want to go back to, but
okay,
since we're looking at the terminated ones right now, but we've always heard, I don't know about New York, but at least we've always heard New Jersey is an at-will state. So how does, if that means that they can fire you at will without any kind of justification, what difference does all that other stuff make?
This is a perfect time for me to give my disclaimer also. This is not legal advice. I can't give legal advice without a signed retainer, but these are general concepts. And I'm a New York attorney, and New York is also an at-will state. Most states are. And what that means is they can fire you for any reason or no reason at all, just not a discriminatory reason. And that's what I look to, and make sure that my clients are treated fairly. But even if you are, and I'll go back to your specific question, but they, with regard to the COVID, if you have COVID and you have to take off, that could come under disability, and you want to check to make sure that you can get paid. So you'd want to go, let's say you suspect you have COVID, you do the responsible thing, you stay home. You want to make sure that you contact your HR, let them know that, ask, if they say, how long are you going to be out? Of course, you don't know, because you don't know how severe it's going to be. You don't know if hopefully it's going to be very short, but you don't know. You want to make sure that you speak to them about short-term disability and possibly long-term disability, and any other benefits that you may have that go beyond your sick leave. You may only have, 3, 4, 5 to 10 days of sick leave. You want to make sure that you use, if they have short-term disability, rather than using your vacation. Because, I try to make sure my clients still have their sick leave left when they come back, because you don't know how long they may have a relapse. So we want to make sure that they're taken care of. Did you have any other questions related to COVID?
Michael Colbert has a question. I don't know. Michael, go ahead, ask your question. I don't know if it's related to COVID, but he's got his hand raised. Michael, you're on mute.
Yes. No, it's not related to COVID. It goes back to the marijuana thing. It doesn't apply to me, but it makes, obviously, me wonder about the laws themselves. The last company I worked with worked in most of the states in the country, because they dealt with housing agencies that built low-income housing, and they're selling bonds to raise the money. So we were told, because we have clients in states where medical marijuana is not legal, even though it's legal in New York, which is where we were headquartered, that doesn't apply to us, because we work with clients in all these other states. So we have to accommodate the most strictest of the rulings.
Michael, can you clarify what you mean? Is this for sales of the bonds?
Yes, well, we managed the bonds. We didn't sell them. We weren't the broker, but we did the cash flow balances, told them when they should sell, when they should call in bonds, because we had the software, to model going forward and predict, as best as possible what these bonds would do.
Yeah, that's really out. I can talk to you offline, and my email is at the bottom I think this is really has to do more with employment, and I don't mean to cut you off. I want to open this up to which are more general questions that would apply to more people.
No, my question is, according to our company, it was against, the rules of the company. But if New York State law says you're allowed to use it, how could the company say, okay, we deal with Nebraska where it's not legal, therefore we have to make it not legal or not allowable in our business?
To use medical marijuana?
Yeah.
Okay, that's okay. I understand what you're saying. I apologize. The medical marijuana issue is pretty clear in New York. It's getting more clear. If you have a prescription to use the medical marijuana and you go to a dispensary, you pick up the marijuana and use it, and you're saying that if that your company still wouldn't allow that?
Right, because we represented clients in states where it wasn't legal.
Right. Okay. That's a really good, that's like a law school question. That's a really interesting question. I love that. Okay, Michael, that's fantastic. So this is where the law is evolving, because you have federal laws that have not opened up yet, and then you've got state laws and also city laws that prevent discrimination against someone with a disability. So if you've got someone who's got a medical condition that requires that they take marijuana, and the company is and they're fully allowed to do that, and they get tested at work, that's where you're going to have a conflict, right? So that's an interesting area. I'm finding that the trends are that if you have a medical marijuana, and even if it's just recreational, even if that's not yet recognized in the state that you're in, they're just going to leave you alone. That's been my experience. The legal issues may be quite different, but with medical marijuana, you're going to have the certainly in say New York City or New York State, the law of use would be on your side if you're not creating a dangerous condition due to impairment at work. And that's where there's, right now, it's very difficult to determine impairment. And so a lot of the companies are just staying out of that arena. That's been my experience, having worked both with the employers and the employees. Nobody's looking for a legal fight. That's been my experience. I hope I helped you. And Michael, please jot down my contact information. You're welcome to reach out to me, because I'm working with some trade groups that work in this area.
All right. Now, I asked the question more because of the fact that how could the laws in Nebraska affect the laws, in New York, for instance?
I think they're relying on the federal laws that haven't recognized use yet, and quite frankly, they may not be right. They may not be correct, but there are all sorts of policies that are created by companies that don't yet know the law because it's evolving. And these companies can be very well-meaning. They're not trying to necessarily be oppressive. They just don't know what the law is, and it's evolving as we speak. My close colleague's got a case up in Buffalo that is really good. You've got a severely physically impaired veteran who worked for the city and was taking medical marijuana and was let go from his job. And this is a decorated veteran who absolutely had a medical condition which required that he take this to alleviate the pain. And the city just doesn't want to hear about it. So where does that leave you? So you're Michael, you hit the question that is, and this also affects areas interstate as well. So you're in a hot area, and I would welcome the opportunity to speak to you after the program.
I would think there's going to be more and more of this. Like, for instance, you know, what if you work for Amazon in New Jersey and we have legalized marijuana here? Of course, it hasn't been put into effect yet, but a year ago we voted it in. Okay, I work in New Jersey. I'm legally allowed to have marijuana, but maybe in, like you said, Nebraska, there's another Amazon and they're not allowed to.
Right.
It's a,
right.
Yeah, so not even medical marijuana anymore. It'll also be just regular.
And what if they determine testing for impairment at work? Well, if it's, you know, there's going to be a testing of the tests. If they don't work that well in the beginning, you know, there's no bright line for somebody's being impaired, but they're looking to create a standardized test that was much like the breathalyzer for impairment.
Sharon?
No, I thought when you're done, there's another question.
Okay.
You ready? Leora, do you want to ask the question?
Give me one moment, just 1 second.
He's gone.
He'll be back. 1 second.
Thanks.
I'm sorry, I had to shut the door.
It's okay.
Okay, go ahead, Leora.
Okay, I have neighbors that smoke, and I don't smoke. I never intend to smoke, but it wafts into my apartment, and the building has told tenants not to, but they still do. And you can't walk the streets of New York anywhere without smelling it anymore in Manhattan. Can that affect me? Will that show up in a test, and how will I be held responsible for that?
Are you talking about your
secondhand smoke?
Secondhand smoke. And you're worried that if you go in and get tested at work, that if it shows up positive, that it might jeopardize your job. Is that what you're saying?
Yes, future job, whatever. I'm not working right now.
Okay. I having looked into this for a while, it may be a really annoying, but where people, at least in New York, where they're allowed to smoke cigarettes, they're generally allowed to smoke marijuana. So if you're allowed to smoke in your rental apartment, then you could smoke marijuana in your rental apartment, as far as I know. That's not an issue I've handled because I deal with more employment, but I understand that this intersects with employment. And I think that if you have a record of complaints about this behavior, then if you're challenged on that, then you would show that record of complaints. You're saying, yeah, I find it offensive too, and I don't smoke, but this has been wafting into my apartment. It would have to be a really sensitive test for you as a non-smoker to come up positive. Having looked into these tests in the past, I think it would be almost impossible, but anything is possible.
Okay, thank you.
Sure.
Gary, I don't know if you have any more, a slide that's going to have to do
with why don't we go to the next slide?
Yeah, because I have some questions about questions at interviews, but go ahead.
Okay, so moving forward, these are some, if you're terminated from your employment, how do you improve the conditions? Oftentimes an employer wants to get a release, right? That's what they're paying for when you leave. If you're offered a severance, what they really want to do is get a release from you. So how do you do that to improve your conditions? Well, do you have commissions that haven't been paid? If I've gotten as little as, let's say commissions are paid out, the annual bonus and commissions are paid out in March for a certain company. And I had that happen where they were then terminated in May, June, and we've been able to get that short 3 months of commissions, and also vesting of equity. It's an area that's really contentious sometimes. And if they've let you go and you have, sometimes the vesting schedule's on a 3-year schedule. If there's 2 years left, oftentimes you can negotiate to get that equity vested so that you have some money to move forward. As I've said before in the beginning of the program, companies don't want to leave you legless. They don't want to cut you off. It's been my experience. They may play hardball in that they are concerned about you filing a grievance against them, some sort of discrimination case, but they really don't want to leave their employees disgruntled and hating the company, because that gets around as a reputation. So these are areas where I have found that there's been a lot of negotiation and wiggle room. You can negotiate for vacation that may not have fully accrued. So if you get terminated in the beginning of the year and you accrue 1.5 days a year, sometimes you can get the remainder of your vacation. And there are other areas, and I'll go into that in a second. So this is one of the other aspects. If you feel you're about to get terminated, or you actually are terminated, I highly recommend you speak with an attorney. One of the things, there are several things that I've done with clients that are not ready to leave, and we can figure out a creative way. We had an insurance, and this was in New Jersey. There was an insurance executive who was highly respected. He was over 60, and he was popular at the company, and he was let go. And what we proposed to them was, I pointed out that I couldn't help but notice his age, and that he was much older than many of the other employees, and that he was valued, and we could determine that pretty quickly based on his sales. And that is there another position for him within the company, or could he just step out? What happened was, I think, I mean, they didn't tell me, but there just wasn't enough money in his area. Why he was chosen, I have my own speculation, but there wasn't enough money in his area to pay him. So they could move. What I suggested is, are there other areas of the company where they could pay him as a consultant? And we were able to get him a consulting gig, which worked out because he could then bridge and do that for a few years until he reached the age of retirement. He was looking to retire fairly soon anyway. But if you think creatively and you propose these, don't expect the company necessarily to be creative, because they see it more in black and white. But if you're not too confrontational, matter of fact, and know the company well enough where there are areas and pockets of money that might be available to tap, consulting is a possibility. Or if you're well liked within the company, you can look, are there other positions that are open that you could start to train for and learn that aspect of the job and make yourself valuable in another area. I always tell my new employees and senior employees, you have to make yourself essential. You work for somebody, even if it's working for the board, if you're the top person, make yourself essential. How can you help the person that you're reporting to, in addition to doing your own job? Because if you're essential to that person, they're not going to want to get rid of you. And I've seen this over and over again, where why is one employee selected over another for termination? And if the essential employee, the person that's made themselves valuable to their supervisor, and their supervisor often survives a cut, and layoffs. So those are important aspects to think about. And then, let's see here. These are some of the awards I've gotten. I've been recognized by the National Organization for Women, the Congresswoman Bella Abzug Leadership Organization, and at the 100th anniversary of the NAACP, I was awarded one of their awards. But really what I want to hear is from all of you. I want to hear, what are your challenges at work, and how can I support you and help you with some suggestions?
We have some questions. Can I read them in the chat?
Sure. And can I go off? Can we stop sharing? Okay, good.
You cannot move a video while someone has their hand raised. Maria, do you want to go? Because I can't do something and your hand is raised.
I have a question, and I apologize, I joined a little late.
Sure,
This whole thing with the COVID testing, can they actually require somebody who works from home to get the jab, number one, or in the alternative to get tested weekly?
That's a great question. I think the way I would propose it to is this if there's no interaction with other employees, then there shouldn't be a concern. If there's interaction with other employees, then I understand the concern. If you're saying that the employee works exclusively from home, doesn't interact with other employees, and there are no other factors involved, I would present that to the company, and that's something I have done in a letter, and oftentimes that alleviates the problem. It doesn't help their employment situation necessarily, because once an attorney gets involved in front of the scenes, from behind the scenes, that's one thing, but once they get a letter from me, the employee is considered a malcontent. So I would be careful engaging. I mean, you want to speak to an attorney, but having the attorney take the front position may be something you want to think about carefully.
No, I understand that. I understand that, but they're insisting somebody who's totally remote get either the jab or tested once a week. No questions asked. And I don't think that they're allowed to encroach upon what somebody's doing in their own home, when for no reason do they ever go step foot on employer grounds, ever.
That's the first time I've heard that argument, not the argument, but that the employer, that somebody's fully remote and they want to test weekly. It seems a little bit of an overreach. I don't know what they would care about, and I would present it as a situation where, as an employee, I don't ever step on or on the grounds, and I don't meet with other employees, and I don't send any correspondence back and forth. So there's no opportunity for anyone to be infected, and I would prefer not to be tested and not to be vaccinated.
Okay.
And if there are other factors,
I might have to do with health insurance, because there's been some speculation about whether or not there's going to be any kind of premium increases because of the extensive cost if somebody is hospitalized during COVID. So perhaps what it has to do is with their health insurance and perhaps other kinds of insurance. That's
been an argument that's a great point, Beth. That's an argument that I have heard, that they're going to require it, and I think it's a legitimate argument. It's not, if you're not going to be covered by insurance, that's going to be a problem.
I'm not covered by their insurance.
I'm not sure what their argument is.
Okay, I just wanted to make sure. Okay, thank you.
Well, Gary,
right. That doesn't mean that they're not going to get upset, but legitimately, why would they care if someone doesn't is not, other than a community policy, but that's not their job.
Right. I agree with you. Thank you.
What's the next?
Well, before we get to the next question, just based on what Beth said, so then can a company say, well, I'm requiring you get a regular flu shot, or I'm requiring you get the measles shot, or whatever, because otherwise your costs are going to be higher on our health insurance? Can a company do that? Totally not related to COVID?
It's coming up more, and that's only been introduced. They oftentimes, companies encourage flu shots, and I've seen that over and over again. But where you see on memos, don't forget to get your flu shot. Really, it's coming to a head right now, where health insurance companies are either refusing to cover or more likely going to charge an extra premium, and the company just doesn't want to deal with it. If they get pushback, then they're going to have to deal with it. So this is one of those gray areas where it's an evolving area of corporate responsibility. They would prefer everybody toe the party line and just do what they recommend. It's a if they get pushback, for particularly if there's a religious reason and certainly a health reason, then they're going to take notice. And in New York, there's some case law preventing mandatory vaccination due to if there's a religious exemption.
Well, I could see someone could say, taking it to the nth degree, well, now we're going to mandate that you have to get your mammogram, or you have to get your colonoscopy, or you have to get an annual. I know that my husband's health insurance, we get a bonus if we do our annual stuff, $50 for a dental cleaning, $50 for a mammogram, but that's encouragement. Is the question is, someone could say, it's not a question, I guess it's just hypothetical. Someone could say, well, where do we draw the line? They're going to require that you do all these health wellness things so that their insurance costs are less.
Except that those things you just mentioned are not public health emergencies. COVID is considered a public health emergency at this time.
Correct.
So it's distinguishable in my mind. That's my take.
Yeah, well, it's similar. Also, companies, health insurance companies will give you a benefit if you go to the gym regularly. If you go to the gym 10 times a month or 2 months, they'll give you a little bit of a bonus. And that's more what you're talking about. This is a public health situation. And, once the federal government got involved, they had a lot more power, particularly over federal workers.
All right. There's a question in the chat. I got an 8-page NDA non-compete at the office closure. My attorney review said it was lock solid, no surprise. But on applications, they ask about a non-compete. I've said yes, and then crickets or email. We went in a different direction. Should I say no? So I guess the question is, as soon as they hear that you have a non-compete, they're not going forward on an interview. Can the person say no on an interview that they don't really have a non-compete if they do have a non-compete?
Well, the problem is that non-competes I find them really offensive, and I think the governments are, certainly California has about the most solid legislation against non-competes. It's if you have to go in, first of all, if you have a non-compete, and does everyone know what that is? If you can't, that means you, in a certain limited area, you can't compete for a certain amount of time. And it's really tough, particularly if they're not paying you during that time. So it's different if you're in what's called garden leave, which some of the financial services companies have, which it usually lasts 3 months. These can go up years. And what the problem is, if you have the concern of there's a chilling effect of just having one. So they don't even, and I think that's what the question was about. They didn't even need to read the non-compete. And this is an area where I talk to my clients all the time and advise them. If you're going to sign something on the way in, oftentimes they're on the way in and they will last 18 months, a year, or 2 years after the relationship ends. You should be really careful that it's very narrow. If you work in advertising, make sure, and it's advertising for, dog food, make sure it's limited to, you can't compete for, for positions that are very, very narrow in a certain area. If you're going to sign it at all. And I try to give pushback on the way in and also on the way out, because what they're paying for, in addition to a release, is they don't want you to be able to work and to encroach on their clients, and that's understandable. But they should have to pay for that. And they. What about?
I'm sorry. What about similar provisions like do not poach our current employees?
A non-solicitation of employees. Those are generally more enforceable in that they don't want you leaving the company, going to another company and taking your whole team. If you're going to go, that's one thing, but they don't want you taking their whole team, and that has happened, and that's the origin of those types of provisions. They don't want you soliciting for a certain amount of time their employees, just like they don't want you soliciting their clients. And but we also want to narrow that to certain fields to make sure that it's not going to hinder the employee's ability to get work going forward. And one of the areas that I talk to when I'm talking to employers is I explain to them, once the issues are flushed out, employers generally don't want to hinder a former employee's ability to get work. So if it's couched in those terms, and I had someone in advertising that we were able to narrow it to, my client was moving to a different area, but the non-compete was very broad. We were able to narrow it, and it was no problem at all. But if you don't announce that you have this, if you're asked, that can create problems later on. If the former employer contacts the current employer, and I've seen that happen. And but if it's going to have a chilling effect on you being employed, you have to make a decision. I don't ever encourage my clients to lie.
So your answer to this question.
Meryl, this was my question.
Oh, okay, go ahead, Elizabeth.
I'm sorry. I just wanted to say that, when I got the notice, I wasn't alone. We all got our 8-page packets. And working in the C-suite, we knew it was going to be rock solid, and it was locked down. And my $450 attorney review told me I had no choice but to sign it because I would lose my cottage garden payments, even though the entire document lasted double the length of time as those payments. Actually, it goes into triple in some of the areas. So when we go now to fill out the applications for jobs, there's always a question, or I've seen it a lot, that says, do you have a non-compete? Yes or no? It's right on the automated ATS system. And I don't even get an opportunity to go to an interview and say, oh, by the way, yes, I have one. However, it's in this area of finance, and I think that, it doesn't apply to this interview. I can't even get that far.
Right, because you get kicked out by AI, right? You don't even get, I get it. So, just going back, I always advise my clients to negotiate any non-competes or not so much the non-solicitation, because then it seems to, it indicates that you're looking to take their employees. So that's probably less negotiable, but certainly the non-competes, they don't want you not to be able to work. One of the things you could go, it's very difficult to renegotiate things afterwards, but you can go back to your former employer and ask them, say, listen, I'm having a hard time getting a job, and I believe it's related directly to this non-compete. Can we talk about that? Because I really need to get a job, and I think you want me to get a job. If the person has a good relationship, we've been able to speak to the former employer and get that limited or eliminated if there's no real reason for it. These provisions started with really high C-suite employees that were going to be compensated anyway, and they've permeated the entire workforce. So if you look at the origin of these, they were not intended for every worker to be governed by a non-compete. So oftentimes when challenged respectfully, they're willing to limit or completely eliminate the non-competes. Especially, I've had an employee that was horrible according to the management, and they wanted them to have a non-compete. And I was like, well, wouldn't you want this person working for your competitor? So we were able to eliminate it that way. You have to be creative with these things, and it is challenging because they just look at a form and they're like, well, you sign the form. Well, next. But if there's a relationship, oftentimes with my clients, I have to humanize them to management, because they're understandably busy. So I want to go in there. I want to tell them, give them an avenue for success. Like, my client doesn't work in New Jersey, but they work in New York. So can we limit it to New Jersey so that they can get their job, and vice versa? Limit it or eliminate it are the aspects that I try to highlight.
Gary, can you say that this non-compete, say in your head, this non-compete really doesn't relate to, like, I'm going to be working in California and not in New York, and just put on, when they ask that question, do you have a non-compete, say no, because it's not relevant to this particular job, or is that against the law?
That's exactly what I was thinking.
Gary? Merrill?
Gary?
Gary's frozen.
Yes.
Gary, hello.
I was going to make a comment that not this past job I got laid off from, but the one I was at the payroll company for almost 10 years. I had my lawyer review my severance documentation, and there was a lot of non-compete stuff, but he basically told me it was boilerplate and really applied to salespeople much more, than it would apply to me, because I wasn't out to be calling on their clients to try to move them to another business. I was a programmer, so I had minimal interaction with the actual clients. So he basically just said, don't worry about these particular paragraphs.
Yeah, that's what I was thinking. Did we lose Gary?
Yeah, we lost him. I'm assuming he's trying to get back in because he must have logged off. So we did lose him. But Elizabeth, I was having the exact same thought that Sharon had, which was, if they're asking you, do you have a non-compete, and your non-compete is really not with what you're interviewing for now, I would also, I don't know how comfortable you feel with it, but I might also say no, because really the non-compete isn't directly related. Does that make any sense to you, Elizabeth?
Yeah, it's not relevant. So, you could.
I am going to keep that in mind going forward, but being in the C-suite, in a public company, I'm finding that it's going to be really hard to say that on the surface.
Unless you speak with an attorney to begin with and ask, how to go.
Well, I did. I mean, for me, I went in, I hired an attorney immediately when I got the 8-page document. And whereas a lot of my colleagues, they weren't about to put that kind of money on the line, I did. And that's why I was told I had to sign it. There was really nothing we could do with it. It was locked solid. And it was in my best interest to sign it. And it made sense at the time, but now it's been almost a year and I keep wondering why I'm not getting the interviews. And this seems to be potentially one of those reasons.
Is your non-compete longer than a year?
Yes.
That's really unusual.
And the non-solicitation is both ways. I can't take anybody and nobody can take me who is a former employee with an unlimited time set, which really hurt me because, of course, the first thing I did was reach out to my former executives and people that we had worked with over the years. And I was told that they couldn't hire me. They told me they couldn't hire me because of it. They already knew. I mean, the industry is that tight.
Yeah, I think I'm sure he will answer later on. We can connect you when he gets back on.
The other thing, Elizabeth, that I would say to you is what we say to everybody who's getting thrown out from the ATS for whatever reason they're getting thrown out for the ATS is you got to get past the ATS, which is to get your resumes through networking to whoever is at the top of the C-suite with you so that they can hear your story before the ATS kicks you out. That's
agreed. Yeah,
that's
absolutely agree.
So.
I've also heard, I know people that, because I was in an organization once that had this, and a lot of people left, had a non-compete, and that this is, you know, you can't count on this, but that judges are 100% in favor of you, the client, because they understand how difficult all they ask is, oh, wait, here's Gary, we're admitting him. Because the judges say if this is how they're making their living, you can't impede them from making their living.
I am terribly sorry.
That's okay.
My Wi-Fi is fine too. I don't know where that happened, but I apologize. It must have been a tough question. I didn't. So please, let's continue. And again, my blue light is on. I don't know what's going on.
In the world of technology, we love it. Anyway, all right. So I think, Elizabeth, you feel like your question's answered at this point?
Yes, thank you.
You're welcome.
Okay, and anyone who has a question for afterwards, or they don't want to speak out loud, please email me and I'll get back to you. And we can even speak as early as this afternoon.
And so here's where's the best place to email you, Gary?
Okay, I'll put it in the chat, but it was in my, it was on my slides. There you go.
Okay, going next, we have someone who asks, why can employers ask applications for graduation dates? Isn't that like asking your age? That's a good one. Hear it all the time. That
is a good one because, you know, oftentimes you'll see on LinkedIn, on resumes, that they just leave that off, and and employers shouldn't be asking that question, in my opinion. I think it opens them up to liability, certainly for possible age discrimination. Can they ask? They can ask whatever they want. They can try. And if you, as a prospective employee applicant, say, hey, this is inappropriate, you know, how do you think they'll react? You know, there's the law, and then there's practical applications. And I think if you point that out to a prospective employer during a job application process, it probably wouldn't go over so well. I would respect it, but and I would thank you for it, but I don't think too many others would.
Hey, Gary, this is Leonard. I have a question. I've seen a couple. I went on a interview over Zoom, and and I know it was illegal to ask, right? But they asked me, "Are you under 40 years of age?"
Wow.
Yeah.
That's like
illegal, right? But they ask it anyway. They ask it anyway.
You know, actually, can anyone else on this panel answer that question? I would say, you know, they're probably opening. That's like asking the, right. You know, when you graduated. So I've never heard that before. So,
yeah.
You know,
and I think, and it was it was a fintech startup. Yeah, it was a fintech startup.
They should have spent more on their employment counsel.
Yeah.
So that brings up a great point that that's often overlooked. Language is evolving too, right? And the idea and concept of the family, of the self, you know, how we view ourselves is all evolving, and I think we need to. I always call people whatever they want to be called. I want to treat people with whatever respect I can, and I want to bring out the best in people. And sometimes I'll hear, like, you know, why do I have to call them this now? Why is it this and not what it used to be when I was growing up? I think that kind of in this day and age, call people what they want to be called, whatever that may be. And I was representing some.
Oh no! Oh no! Did we lose him again? Gary, come back! I feel like the Wizard of Oz. Gary, come back! You're back.
Okay, I apologize. Just I'll just say, call people what they want to be called, and just make sure that they are treated with respect. And that goes both ways, if you're an employee or an employer, but particularly if you're an employer.
I have a question. On some of the online applications, or on many of them, there comes a point where if you don't answer the question, you can't move forward. Is that right? Whether it's what year you graduated or your last salary or any of that, isn't that kind of a place where you're going to get stopped, where you're absolutely forced to answer the question whether you want to or not, or whether it's, I don't know, legal or not?
You know, I worked, I sat on a panel, and there were two members of the panel that worked in the area of artificial intelligence and where these applications where they kick you out, and that might be a good area for a program. Meryl, you might want to bring someone in, and I have somebody in mind that might be able to help you out, because you're absolutely right. Like, just like any other application, when you're working online and you can't answer the question, there's no yes or no or whatever the options are. How do you answer that? And you have to do the best you can.
Well, the best you can is you have to put something down. And I thought the point of the discussion was, if you're face to face with somebody, or even on Zoom, you can amplify your right. What's going on. But when you're dealing with the black box, you either fill it in, or you can't go to the next question and you can't complete the application. Is that in and of itself? Obviously, it's not illegal, because companies do it all the time. I was just wondering what your opinion was on that approach.
I don't think too highly of these automated applications, but that's the world we live in. So you have to do the best, answer it to the best of your ability and move on. And then if you need to explain it later, if someone says, well, you didn't answer this correctly, you say, I answered it to the best of my ability. I was only given these two possibilities, or whatever it is. You might want to take a photo of a screenshot or a photo of the questioning of concern, so that you can relate it back if you're asked in an interview. But I've had clients have that problem as well. There's only so much you can do if you don't have a human in front of you to explain a situation. But that's a very good question, and it happens all the time now.
Yes, thank you.
I've had my hand up for a while. And we've passed the topic already, but this goes back to the COVID situation. I know of people who were pretty much forced to return to the office, even if they didn't want to. And things I've been reading indicate people, when they've gotten up to my age level, for instance, are the most careful when it comes to COVID, because we know, as you get older, you can be more vulnerable to it. If you have a condition such, for instance, that you can even get a letter from a doctor saying you shouldn't be, in with a group of people very closely, can they still force you to return to the office?
That's a great question. So if you have a medical condition, you could have your physician confirm that you have this medical condition that would be against medical advice to return to the office. It's a particularly compelling argument if you have been working for the last year and a half successfully from home. Then they would have less of an argument to make that you need to come in. But I'm seeing this all the time, particularly in New York. They want to amortize their real estate investment, and they want to make sure people are there. And I think there's still a mentality by management that if I'm not seeing it get done, it's not getting done at least as well. I disagree, because unfortunately, many of us feel we're working all the time from home, and we're answering emails all the time. But your doctor should be able to help in this instance. There's one qualification which I think is irresponsible on the part of employers and the government, is, at least where I've seen it, they don't recognize other members of your family. Let's say that you're somebody young who lives with somebody who has a medical condition. You're young and healthy, but what about your family? And that's a problem. That's a problem that I'm seeing, and I think that's where you would need help from a creative attorney and a helpful doctor.
What if the person is not sick but feels that they can do the job?
That's the issue. If they're not sick but they live with somebody who's highly compromised, what do? That's because they're not recognized. I think the policy is that they can't. This could go to infinity, right? You can say, well, I come in. It is a very difficult situation, and it's heartbreaking when people have to leave their employment, or they feel their employment's going to be compromised because they can't jeopardize their family member.
What's the legal answer? Like, legally, can you force somebody to work remotely if they've already worked remotely for 1.5 years and done a great job, and they want to stay being remote? Is it legal to force them to come back or get fired?
They can demand you come back to work. At least in New York, they may not have a. I think that's where you want to have a conversation with your employer and talk to them about, even though you've been successful working from home, right? So you have a track record of success, and I think that's important. And this also is something you want to document. If you're working from home on a regular basis, I often encourage my clients to send a week and Friday review. This is what I've done. And always make it expansive, including the following highlights. So if they go back and say, well, what do you mean you didn't do this? No, I did that. That was just not on my highlights list. So you don't want to limit it, but you want to. So on Fridays you send in a highlight list, but they can demand, like, listen, the job requires that you come in. You're not sick. There's no medical reason why you can't come in. We need you here. And that's where I think you need to have, employers need to have a strong HR. There needs to be much more empathy within the workforce. And employees are going to remember if their employers treat them well during this really highly anxious time. Many employees are, they're talking about the great resignation. Well, I think the great resignation is the high anxiety of employees, and employers are and they also say, well, these employees are demanding more money. Well, if you're going to jeopardize your family and you're going to jeopardize your own health, you need to be paid for that. So I think it's a perspective issue where the employers are they oftentimes you hear, like, we can't get anyone to work. Really? You can't get anyone to work for any price? So I think there, and I encourage my employers to be more empathetic, particularly during this time. And I think that's going to create a more loyal workforce.
All right, I'm going to take a break here. It's 9:14, 9:15, 11:15. What am I talking about? Don't go away. I know there's more questions in the chat box. I know other people have questions who are raising their hands, but we need to get an evaluation filled out. So I have just put into the chat box, for those of you who are new to the program, just click on the blue part where it says forms.gle, or copy and paste it. Sharon's going to time us for 3 minutes. It is super, super, super important that we get these evaluations filled out in detail. Less and less of you are doing that. I know you're getting a little bored every time you have to do it, but it's really important both for us to help our speakers going forwards. I give them direct feedback on what you say, and also helps us to improve our programming going forward.
It would mean a lot to me. Feedback to me is a gift. I'm a scout leader, and feedback to me is a big gift, and I want to hear, be tough on me.
All right, so go do that. Sharon's going to time us. Sharon, take us away. 3 minutes.
Okay. Okay, we have 30 seconds left. Can always finish it after.
Joe has some cute dog there.
Yeah, and he always is so positive in his evaluations. Okie dokie, 3 minutes are up. You can finish it later if you have to.
Okay, we had something about an IPO where I have to go find it.
Yes, I'm interviewing for a small private medical device company, and things look very positive. The company is planning an IPO within the next year or slightly longer. If Howard hired, how should I handle this? Ellen, did you want to add anything to that question? You're on mute, Ellen. You're on mute. You're muted, Ellen. You have to unmute.
Can't hear you, Ellen.
Ellen, we can't hear you. Can you unmute her, Meryl?
Yeah, I probably
can't find her.
I was trying. Thank you. So I was trying. I was finishing the survey and I couldn't get back to you. Yes, I had 8.5 hours of interviews yesterday afternoon.
Congratulations.
And thank you. I'm so lucky. And I have the medical device company has a very specific set of criteria. They want an electrical engineer who has medical device experience, who's working as a project manager in New Jersey, and the stars are aligned. I meet all those requirements. And then bottom line is things are looking very well. And the vice president of HR yesterday kind of inadvertently slipped and said, we'll be glad when we have you here, or something like that. So I'm thinking this is going to go well. And they are planning an IPO within a year, possibly a year and a half. So I'm not sure how to address that moving forward. But since I typed in my question, I'm realizing that this is a larger topic that I probably need to follow up to see if we can work together, because the whole compensation and benefits, you know, any non-compete or anything should be addressed before.
That is a great question, Ellen, and it is a broader question, but let me just answer it briefly. There was a great article 2-3 days ago in the Wall Street Journal on women need to negotiate for equity, and take a look at that. And you can, if you email me, I'll email you the article, because I actually just posted it on LinkedIn. And please, everyone, reach out to me on LinkedIn and let's connect. But if you look on my LinkedIn, you can find it, or you can email me. And that'll give you a start, and then you can reach out to me if you'd like. That's fine. But you really, equity at this point, especially in that field, which is exploding, right? They you know, and especially since they've gotten a boost since, you know, maybe not directly, but with drugs price caps being removed from the legislation. I think it was yesterday. You know, medical has all gotten a little boost. So you are in a very good position if you can negotiate some equity. Good luck to you.
And Ellen, don't forget us after you get the job. If you hear about open jobs, give Meryl a call.
I love that.
Yes, it's always about paying it forward. All right, Leora had another question. What can an ex-employer reveal about you after you've left legally, and what happens when your old company is sold?
Okay, so I get the first question. What can a former employer reveal about you?
If someone calls and says, you know, Meryl was working for JVS for 23 years, can you tell me why you let her go, or something like that? Can they say that?
It's been my experience that employers don't want to say anything that is going to deviate. And if you look at your at the handbook, or even your contract, and certainly your release leaving, they will often say that all we give is when you worked and what you did. And they don't want to expose themselves to potential slander libel. So if they're making untruth statements, they're going to, just like anyone else would be liable for, you know, for slander, libel, whatever that may be. But it's been my experience that employers tend to say much less than they should, and oftentimes will hurt the employee inadvertently because they just don't want to reveal any information that might open them up. And the second question, I would need some more information on that. I didn't quite understand.
Leora, do you want to unmute yourself?
Sure. So when a company is sold to another company, what do you do then for references, and what will they have access to your information, and will they want to reveal more because they're not really on the hook like the previous one was?
I would think they'd probably only reveal when you work there. Why would they want to open themselves up to liability? So I don't think that's going to affect at all. And it may be they want to narrow what they talk about even more. But more and more companies, they don't want to be in the business of opening themselves up to liability. So they're only going to give the dates of employment and what you did.
And they'll have access to that too.
It depends on that varies. That, you know, if you're saying at some point the records may not carry into a new company, but you could also call up the new company and say, hey, I'm applying for a job. Can you just keep my file nearby HR so you have it on record that, you know, when I worked there? That would not be an unreasonable thing to do.
Okay, thank you.
Sure.
Any other questions? Anybody else have a question?
I just have a quick one for Gary. the last company I worked with, this financial company, I don't know how many companies do this, but it would seem to me it's not the greatest thing. Our CEO was also the head of HR and our compliance officer, and he only held these positions because his uncle owned the company, but I don't think he was actually trained in any of those areas at all yet. And I think the severance package he gave me, one of the kids of the owner of the company was a lawyer, a 20-something-year-old lawyer. So I think it was all probably just boilerplate, you know, off the internet. To me, it just seems, you know, not the greatest idea to run a company where one person holds all those varied positions and has no education or background in any of them.
So to the extent, if I understand you correctly, you're saying, would it have been better to have separate roles of CEO and HR and compliance? Absolutely, because you have more opinions and expertise in the area. But oftentimes with small startups, you know, especially if you're one person, you're everything. So that's happening more and more with small startups.
Oh, this wasn't a startup. They've been in business since the 70s.
Well, clearly it's not a good practice, but it's something they did. There was a question from Hope that I saw before, and thank you for Hope for putting it back in there again. I know we talked about NDAs before, but can you talk about signing NDAs before having conversations about consulting work? From personal experience, often signed NDAs are required just to have a conversation, which is laborious and time consuming, especially for consultants. Also, I found some NDAs to be very restrictive, hard for consultants to push back on certain legal statements. So I guess the question is more about, well, I know we talked about NDAs before, but is there anything different in terms of being a consultant?
Sure. So if you're going in as a consultant and they don't want you to disclose, that's different. They don't want you, you know, and I limit it to trade secrets. Obviously, you know, you're not looking to disclose any trade secrets or anything that's inappropriate about the company. You're not looking to embarrass them. So if it's just non-disclosure, I usually advise my clients, you know, read it carefully and have me read it. But that's a very different animal than a non-compete. You're just not disclosing. And oftentimes to even speak, you know, when my clients will speak to somebody at a company and they're getting near an employment threshold, they will have an NDA. They just don't want it. They don't want their private matters disclosed, especially in small companies, if they have some proprietary information that they're going to reveal.
Hope, does that answer your question? Hope you're still there. Okay.
Okay, so we have another question. If a former employer outsources the third-party referral and a prospective employer is asking to speak to your former supervisor, how should one approach this dilemma?
I think I need an org chart for that.
I had to read it twice myself. You want me to read it again?
I could come a voice if that will help.
Yeah, that'd be great, Gene.
Yeah, so this is the situation. One of my former employers was very adamant that they don't provide employer referral. So they have hired a third party. It's like an 800 number. If somebody wants to check about your tenure or whatever you did for that company, they speak to this third party. So recently, I was going through an interview process where they asked for my referral, and I provided them with the 800 number that my former employer had given me. But they said, no, they wouldn't do that because they want to speak to the supervisor. Now, that was in violation of the agreement I have with my last organization. So I was like in a quandary because I knew that I was not allowed to give anybody's name for them to be contacted. But
I understand. This is where the employer hires like an HR consultant firm and then you would look to them for the referral. For just to Well, it's not unreasonable for you to contact the employer and say, listen, I'm really looking for a job, and all I'm looking for is you to confirm that I work there. And particularly if it's somebody that you did good work for, they are much more likely to provide you a positive reference. So I always encourage my clients to try to get a referral, oftentimes in writing, from their immediate supervisor, and that may be outside of the role of HR. That way you've always got that. And you can hopefully get your supervisor where you worked to talk about what you did, if that's what you're trying to do, to give more specifics beyond where you actually worked and when in the time you worked there. So if human connection makes such a difference. And I don't think I have to tell anyone here that, if you can make a human connection with your old employer, your immediate supervisor, even if you were laid off or something else happened, that makes a big difference. And then with the new employer, try to make that connection, but don't do it without permission.
Thank you. Yeah, because it was a company policy that, everybody has to go through that third party. And they could only confirm your rank, your salary, and your employment. And
there are often times that is the case. There are policies, and then there are practices, and they sometimes are very different. And that's why you want to get in touch with, if you and your supervisor were tight, had a great relationship, then maybe make that direct connection with the supervisor, just sidestepping HR.
Thank you.
Sure.
And then there was another question reposted. As a non-executive professional, how much leverage do we have re alternatives to severance options? From personal experience, the company just wants to release you, but they dig in and do not want to make concessions. So I guess if they don't want to give you severance, do you have any way of getting it?
No, but you can look. They can get rid of you and not pay any severance. What they're generally paying for with severance is for you to agree to certain conditions. One of the conditions is that you're not going to sue them, right? And that provides them some peace of mind. So, but if you have no legal recourse, there's no guarantee that you're going to get a severance. I oftentimes remind the corporate former employer of my client that, I couldn't help but notice that my client was the only woman in her division, and she's now not working there. Or point out something that you're not saying anything other than, it looks a little strange. And, she or he are just trying to move on to their next opportunity and looking for a cushion so that they can make that transition a little bit easier.
Along those lines, Gary, one of the companies I worked for was sold. I was laid off before they were sold, and I got severance according to the years I was there. But the people who were with the company after it was sold, a bunch of them were laid off, and they were considered to have less than a year with the company. So 20-year people got nothing for severance. One of the guys, he got into such a legal hassle with him, he actually got sick over it and passed away, because he had been, with the original company for 20, 22 years. He was well over 50, and
employment transition can be very stressful. I encourage my clients to make sure that they take advantage of the benefits that are with the old company, and if they have COBRA, to make sure that they take care of themselves medically. This is a great transition, because we all have to be, these are extremely stressful times, and the more that we can take care of our mind, our body, our spirit, the better we're going to be, the more helpful I'm going to be to my family, to my clients, to my employer clients. If I take care of myself, I get up early in the morning, I exercise, I try to eat right, although that's not always perfect. And I try to take care of myself, and that is so important. Sometimes employees, have to move on, and even if they're in litigation, that can't consume them. They have to look for another job, and they have to move on. And I've had to do that when my clients sometimes get into litigation with their former employers. That can't be their job. Their job is they have to get a job. They can't look to this as their end all be all, and that's not or a windfall. They need to make sure that they're healthy in mind and body to move on to their next opportunity. I know that wasn't a direct response, but employers can change their policies, and oftentimes do. One employer who gets bought out by another employer may cut the severance benefits and have or if there's some sort of reduction in force, that may be one criteria, and it may be much lower once that's done.
Okay, and we're going to take one more question because we're already over time. Nancy, I know you had a question having to do with negotiating with government agencies. I've seen it a few times pop up. Can you unmute yourself and just say it straightforward and clearly? Nancy, you still here?
Yeah, I'm here.
Go ahead.
So my question is, there are certain companies that are hard to negotiate with. Like, I worked for the Federal Reserve Bank, and they also did not give me my letter with everything in it until my last day. They wouldn't let me see it ahead of time, which wasn't good either.
Right. So your question is, how do you negotiate with someone that doesn't want to negotiate? Right. Okay. So that's always a question, and one of the it's a problem. One of the challenges is finding someone at the organization who was supportive of what you did, and trying to get them to go to bat for you. And what I mean by that is I encourage my clients to reach out to, let's say, their supervisor. They were tight with their supervisor, or their supervisor's supervisor, or someone that may have even moved into another area. Now, at the Federal Reserve, or sometimes at government organizations or any organization, they might not be willing to make that leap for you, and you're just going to have to accept that. I mean, but that doesn't mean you can't ask. If you're not happy with your severance, and that's where you speak to a lawyer if you think you have any arguable claim. But even so, lawyers can help you negotiate severance, and they can do that by, I've had so many clients that have come into me not thinking they had any claim, and I'll be like, really, you were the only female in this entire floor? I had a foreign bank where they had removed the women's restroom on the floor.
Oh my God.
So, there might be areas, and, that was an egregious one. There's no animus here. We're just, needed that space, and we had to remove one of the restrooms. So sorry. I can't say that, sometimes you just get rejected from a job, and there's no negotiating. But if you can negotiate, if there's somebody in there that you can speak to, I'm a big fan of humanizing the condition. If you talk to somebody, you just say, listen, I just need to get to my next opportunity. Could we talk about, health benefits for myself and my family? Whatever it is, a discussion often helps. Getting in front of that person is sometimes challenging, and there's ways to do that, and that's why you might want to speak to an attorney.
Well, for me, it's too late, but I tried. I spoke to an executive vice president in HR. I spoke to the ombudsperson. I spoke to EEO. And even though they were getting rid of over 55s and only over 50s, like a few, one at a time over the last few years, they got rid of about 6 people that were all over 50. But yet they didn't eliminate positions for anybody younger. So
that's interesting, and that's something, you can point out. You could go to an attorney, they can point that out, and if there's a legitimate claim, they can go to the EEOC or one of the other agencies, whether it be state or local, and pursue that claim. And oftentimes that will bring the employer to if done correctly, it can bring the employer to the table to negotiate. Sometimes they'll dig in, though. You don't know.
Nancy, at the Federal Reserve, are those GS level type positions, or is it outside?
It's a quasi-government, it's an government agency, so it's not G-scale.
Okay.
Yeah, they're independent.
I know I said one more question, but I think Pierre had a question. Last one, really last one. Negotiating legal terms. Oh, where did it just go? It bounced off. Where was it? There it is. Negotiating legal terms when applying for a job. What if they say no to modifying the contract?
If they say no,
yeah.
But a negotiation is just that, and oftentimes it's presented as one-sided and take it or leave it. And let's face it, the employers are generally in a better position to say yes or no, because there's in certain markets, there are lots of applicants looking at few spots. So they can just say, no, I'm not going to negotiate. That's what I do all day. And I persuade entities that they do want to negotiate when they don't. The Boy Scouts, when we went over there and asked them to let girls in, what do you think we heard? So, we try to negotiate all the time, and it's very rarely someone says, you know what, that's a great idea, and accepts it. Let me borrow your pen, I'll make that change. So, that's the negotiation. And, it really, I try to make it, rather than an adversarial process, into a collaborative process. Like, how can we work better together so that this employee is going to be really jazzed about coming in here? You don't want to bring in an employee, after you've slain them in negotiations. You want everybody to be on the same side. So that's been my experience. It doesn't always work, but sometimes it does, and it's worth a shot. And oftentimes you're being judged on how do you negotiate. If you're going to be in a position where you're going to be negotiating for the company, they surely want to see that you negotiate.
All right,
wait, don't stop.
Okay, go ahead.
I'm sorry. Jean, you wanted to know a question. Why would a headhunter, go ahead, you want to ask whether you got severance when you left your last job? I have an opinion on that too, but you tell me.
Yeah. I mean, I think that was unusual because I was approached by somebody for an opportunity, and as we were going through my background, she was adamant in knowing whether I got a severance when I left my last position. So I didn't know why was that relevant on my qualification. Actually, we were discussing my qualification for the job, not my personal private life. So I don't know if you have any.
Okay. I'm going to have Gary's opinion too, but I just want everyone to know there's good and bad in the world, right? And people, and there's good and bad in headhunters and in recruiters. And you have to be very, very careful if you get a question like this. It's none of their business, and but anyway, Gary, you want to take over? I would just be very careful what they ask you, and just say, I would even say, well, why is that relevant to this?
Yeah, I mean, I have my knee-jerk reaction is one thing. You're trying to preserve the relationship, but why would they ask that? I think they were probably trying to figure out how desperate you were for your next opportunity, and how much they could, they deal with the employer every day. They may deal with you once. So they may have been trying to figure out if they could, what number they could pick you up for. I'm speculating, but does anybody else have any ideas on that? It's not a question that's fair, in my opinion.
And most of these interviews are not fair anymore. I don't know if you've been on any recently, but Meryl and I have a lot of experience. Then fair has been thrown out the window.
Right, they're pretty brutal.
Brutal.
I think
yeah, I'm sorry they did that, but I can't say I'm surprised.
But I think when you get any of these legal questions, and I think what Sharon said was 100% correct, is, I mean, you don't want to say, why the hell are you asking that question? You want to say, I'd really like to understand why you're asking that question, like in a nice way, like, how is that relevant to this discussion here? I'd really like to understand that.
Yeah, can we explore
like
that?
Said, you know? Collaborate, right? Can we explore that? That's a great way to put it.
Or talk about something else. They're not going to go back to it if you don't. You know, they're not going to. Sometimes, and this is with anything they ask that's none of their business. You can just change the subject. You know, like, well, how old are you? Well, yeah. Oh, that's cute. That's a good thing.
Well, and sometimes an inappropriate question is just someone trying to make small talk. You know, oh, did you see the game? Did you go with your kid? Well, you know, that's intrusive, right? But it's also small talk, and they sometimes people overreach. We're in an era where families look different, you know, and a family can be one, and it can be, you know, you're trying to get, employers should be trying to get the best worker they can get, and oftentimes without well-meaning workers can ask really dumb questions. Well, employers, I mean, can ask really dumb questions that are seemingly offensive, but they're just not insensitive.
Well, especially managers, young or inexperienced for hiring, they don't know.
Right. What Sharon and I have found is most people doing interviewing have no idea how to interview. That's a shame, but that's the truth. So anyway, it is 11:48 and this is way over time. So first of all, I want a big round of applause and a thank you for Gary, who has given of his very precious and valuable time over the last almost 3 hours to talk to us about all these wonderful issues. He has also been incredibly gracious. His email is in the chat box. If you want to reach out to him directly, he's more than happy to answer questions within reason until he starts, you know, turning on the dollar signs. But no, I'm just joking. Gary's been amazing, and I'm so glad you're here.
I'm honored to be here. I wish you all continued success, and you know, trust me, you've helped me a lot. I love being here and being such a you know, an energetic crew, and you're lucky to have such a resource. You know, Meryl and Sharon, you do a tremendous job, and if I can be of any service in the future, please reach out.
Thank you. Absolutely. And for all those of you on the program, 2 weeks from now, one of the hottest topics we ever have, which fits right into today's conversation, we have Ed Lawrence, who's going to talk about ageism in the workplace and the hiring place. And I know that always gets us a really big turnout. So we're really excited about this. Ed comes recommended from 3 of our other speakers. So I know he's going to be terrific. You'll be getting a flyer on that as soon as I can put it together.
That should be a great program.
Yeah, I'm really excited about it. In the meantime, I'm really hoping that none of you will be on the program because you all have landed jobs. But if you haven't, then first of all, if you have any questions about what JVS can do for you personally, one-on-one, then I have put several times into the chat box my name and email, Sharon's name and email. Please reach out to us and we will get back to you as soon as possible and explain how JVS works. For any, including this program and every previous program that we have recorded, I also posted the JVS YouTube channel where all those programs are. You can go back and review them. If you want a copy of Gary's slides, he did send them to me this morning. I'm going to save them. And if you send me an email within the next couple of days, I will get back to you and I will try to send that out to you. And otherwise, everyone just stay healthy. That's the most important part. Enjoy the beautiful weather, but be safe, be careful, stay healthy, and hopefully you'll all land before. If you do land, please let Sharon and I know, because that's what keeps us going, is hearing good news. We love celebrating good news. And again, Gary, thank you so much for everything. And have a great day, everybody.
Thank you for all you do. Take care, everybody. Have a great day.
Thanks so much, Gary. Thanks, everyone.
Thank
Bye.
You.
Bye-bye.